Thank you. And we have a presentation. Good morning, Commissioners. For today's presentation, our focus will be on public access to the coast, but that is only one component of our work, since we also work on protecting wildlife habitats and coastal views and other coastal resources. There we go. And next slide, please. With respect to public access, the California coast can be thought of as our most extensive public open space that everyone has a right to use under the state constitution. With so many communities with a dearth of public spaces, as a matter of environmental justice, the coast needs to be available to help fill the gap for recreation and mental well-being. Yet, although enjoying the coast is fairly uncomplicated, and you can do so by plopping yourself down on the sand and gazing at the waves, there are many impediments to access that make the simple act of enjoying the coast prohibitively difficult, especially for everyone that isn't one of the fortunate and very limited few beachfront residents. And could we get the next slide, please? And actually the next one too. Thank you. Thankfully, during the 50 years of the Coastal Act, the Commission has taken on many different threats to access. And in 2014, the state legislature, with much input from staff and the public, provided the Commission with a game-changing tool. That is the administrative authority to assess monetary penalties for public access violations. And for brief background, Section 3821 allows the Commission to impose, by a majority vote at a hearing, an administrative civil penalty for violations of the public access provisions of the Coastal Act. The maximum penalty is $11,250 per day per violation. Next slide, please. That said, in practice, much of the value of Section 3821 is in its deterrent effect and leverage to resolve cases amicably. 3821 has led to restored access, public access in a far faster time frame than we might typically see, without ever requiring the issuance of penalties. In addition, with the authority of 3821 underpinning our district level negotiations, we have been markedly more successful and creative in achieving resolutions that don't just reverse violations, but which also provide significant benefits to the public to mitigate for the violation's harms to coastal resources and to address the Commission's claims for monetary penalties. We'll cover a couple types of these resolutions in this presentation. Next slide. The threats to public access that we deal with are varied and numerous. So to provide some structure to this presentation, we are going to look at the violations in the sequence that a typical beachgoer might encounter them during a hypothetical trip to the beach, including parking restrictions, beach curfews, security guards, physical barriers, access encroachments, localism, beach restrictions, and lack of affordable accommodations. But this is not intended to be a depressing exploration of limitations on beach access, as we'll also cover how Commission staff have resolved these issues. And these cases are currently the work of our Southern California enforcement officers, so Marcia Venegas in San Diego, Spencer Sayer, Diana Garcia, and Dewey Henry in Long Beach, and Cameron Lee and Carla Rivas in Ventura, a third of which are working on a special project for case backlog reduction. And next slide, please. And we're going to cover a very small sample of our cases today. The point is to illustrate how our program has evolved with 3821 to achieve more and more coastal access for the public. We'll start with the first threat to public access that our beachgoer encounters. That is the especially pernicious no parking signs decorating public access parking spaces. Signs like these are easy to fabricate and install, but it's difficult for the public to determine if they are legitimate. This sign is not, as it was installed in a parking area that the Commission required to be public to provide access to the adjacent Agua Hedionda Lagoon in Carlsbad. Next slide, please. And after researching and confirming the permit history for the site, staff directed the HOA to remove the unpermitted signs and to install the Commission-required access signs. Next slide. And in addition, to help mitigate for the impacts of the unpermitted signs and resultant loss of parking, our San Diego enforcement staff negotiated for the opening of a new public park at the site through conversion of a previous HOA common area to public open space. And on this slide is the new public park overlooking the lagoon. Next slide, please. The public park and parking provide access to the trails and sandy beach at the lagoon, and you can just make out people enjoying the beach in the background. This resolution is typical of our approach to resolve violations through condition compliance, and in addition, with the help of leveraging Section 3821, securing additional benefits for the public, such as the public park, in order to mitigate for impacts of the violations and resolve monetary penalties. Next slide. And here you can see our typical approach is to include attribution to the Coastal Commission on the signs to help the public understand our role in providing access, but also to highlight whom they should call if there's an issue. And of course, we have many resources online and through social media to spotlight public access opportunities. Next slide and next case. So once our beachgoer has found parking, they might encounter beach hours or curfews posted at an accessway. As the commission will remember, last month, the commission supported limited hours of access to a trail through pocket mouse habitat in Dana Point, a truly unique situation. More commonly, the commission requires hours of access to be maximized to ensure the availability of beaches at different times to different users, including mornings and evenings, before and after work. In this case, though, also in Dana Point, the city and a developer of a luxury residential project had coordinated without a coastal development permit to reduce access hours to multiple walkways through the project, and installed gates and unwelcoming spike fences at beach accessway entrances, which you can see on the screen, and which discourage access. Security guards service the gates, thus introducing uncertainty with the gate operation and creating the chilling effect private security can have on access. Next slide. After district staff had prepared the case, it was ultimately resolved through formal enforcement action that required the city to, among other things, remove the spikes on the fences and the gates on the accessways, and to make the accessways less foreboding to visitors, and to expand hours of access. Next slide. 24-hour access to the beach was also required by the commission to resolve the case. And next slide. And this is the beach and walkway at the base of the accessways. It's also important to note that the city had challenged staff's position in this case in court, but with the AG's office representing the commission and Surfrider also playing a key role, that litigation ultimately confirmed the commission's jurisdiction to take enforcement action and resulted in case law that effectively says local governments cannot treat public access as a public nuisance without cause. And next slide. Occasionally, barriers to access have been in place for so long that they predate the Coastal Act and stand as frustrating reminders of the days before the commission's authority went into effect. This fence into the water at the north end of Malibu Lagoon State Beach is such an example. Next slide. When portions of the fence were replaced in 2016, though, commission staff jumped on it and argued under relevant statutory language and case law, whatever vested right that the applicant might have had to the fence had been lost with its replacement, and directed the homeowner to take the fence down on the beach, which they did, as you can see here. Next slide, please. And some relic debris remains in tidelands, but the path up the coast is now clear with the fence removed. And next slide. And here's the beach continuing up the coast from the site in front of the Malibu colony. Next slide. Our theoretical beachgoer has now reached the beach and is looking for a spot in the sand, but they're about to encounter a new set of impediments to access. There's a near constant creep of private development onto public land as homeowners illegally co-opt public land next to their houses for their own use. This is an obvious example where a homeowner had privatized an area of El Matador State Beach in Malibu for their own use at the exclusion of the public. The sand within the fence is entirely publicly owned state beach. Next slide. but the homeowner quickly took the fence down when directed to do so by enforcement staff. Next slide. Some privatization of public land is more entrenched though, such as private yards that have proliferated at many beaches statewide as homeowners illegally expand their yard space onto public beach. For instance, at the Balboa Peninsula at Newport Beach, dozens of encroachments such as this one created a community-wide violation. This is a typical occurrence when one party places encroachments, neighbors take note, and such encroachments tend to spread down the beach like dominoes, each taking up public land with private development for private uses, adding up to significant loss of sandy beach. This is entirely on public beach, this lawn and play area. This situation necessitated years of work at the district level to research property rights, permit and LCP history, and then engage with dozens of homeowners at town halls to seek a resolution, and then work on settlement offers and discussions with the dozens of parties. Next slide, please. The resolution ultimately came in the form of a consent enforcement order directing the city and homeowners to remove all of the encroachments and for the homeowners to pay over $1.7 million in monetary penalties. This money, like all monetary fines for coastal act violations, is not paid to the commission. Instead, this fine has been paid into the violation remediation account, where it is dispersed to benefit public access and habitats for wildlife species. Here's a representative encroachment with ornamental landscaping planted far out onto the public beach. Keep an eye on the pole for the volleyball court on the right for reference. And next slide. And here's the encroachment removed and the sand freed up again for public use. This simple fencing is temporary, by the way, as dune vegetation is planted. Next slide. The next couple of cases are especially distressing as they demonstrate continued attempts by some beachfront residents to exclude visitors from the coast. This can constitute development under the definition in the Coastal Act that the Commission regulates because the activity changes access to the coast. This case came to us by way of a post on TikTok when a beachgoer posted their interaction with a resident in Laguna Beach who was verbally harassing beachgoers and installing a makeshift rope barrier to exclude the public from an area of the beach that was in fact public. And you can see down I guess it's kind of hard to see in the lower left, that when we launched our investigation and screenshot the video, it had already received 3.2 million views, which is testament to the immense public interest in the issues that the Commission deals with. Next slide, please. And here is an excerpt of the video. A warning, it's disturbing behavior. If you can play that, Chris.
Not harassment on the beach, it's harassment in my home property. Whoa. Get out of here. Now.
Enforcement staff contacted the individual that posted the video to establish the facts of the situation to build a case, research property lines and easements on the beach, and then send a notice of violation letter to the resident. At staff's direction, they immediately removed the rope barrier and committed in writing not to interfere with public access. And thus, within days of staff seeing the video posted, the violation had been corrected. And next slide. And once the beach had been freed of obstructions, staff shot our own video and posted it online. Can you play that too, please? And here is the beach, free of that barrier. Okay, and next slide, please. In the next case involving the so-called Lanada Bay Boys in Palos Verdes Estates, the notorious harassment of visitors by local surfers was largely conducted out of a stone fort, which itself was also an unpermitted structure. Next slide. This shot shows that the fort was practically loomed over the waves and thus was in a prime location next to the surf break as a base for the Bay Boys to intimidate visitors. Next slide. The localism and exclusion of visitors at Lanada Bay has been a topic of public interest and media coverage for years. And we considered how we could weigh in on this, and staff crafted an approach to make the site more welcoming for the public. For instance, given it was unpermitted, commission staff requested that the city either take down the fort or improve and permit it as a public amenity. The city chose to tear it down. Here are city contractors at work dismantling the fort. And next slide. The structure was a substantial edifice, and its full removal required air support. You might be aware that contemporaneously with staff's efforts to remove the fort, private parties sued the city and the Bay Boys individually to address the harassment of visitors. This litigation was based on the theory posited in staff's letters to the city that the behavior of individuals to exclude the public from the coast is development under the Coastal Act, and the city was responsible to curb that behavior where it occurred on its property. In the litigation, commission and enforcement and legal staff collaborated with the AG's office on litigation support, including filing an amicus brief, and obtained favorable case law that confirmed staff's theory that the behavior of individuals to exclude the public from the coast is development under the Coastal Act. This situation illustrates how staff continued to explore the possibilities of the Coastal Act, interpret it broadly to bring the most benefit to the public. Next slide. And second to last case here. Our visitor to the coast wants to go fishing, which often can be in the form of subsistence fishing for individuals and families. Thus, the commission approaches providing fishing opportunities as a matter of environmental justice, and staff works to ensure fishing amenities and locations are available and free of obstructions. As an example, a marina in Huntington Harbor had not installed a public fishing pier as required by a coastal permit. The marina instead was signed as a private marina, as you can see here. Next slide. After an extensive process to identify the optimal location of the fishing pier as far as angling productivity and enjoyment, the marina operator installed and opened a new fishing pier, shown here. Next slide. The pier is now clearly signed for public use and includes informational signage about local fish species and fish habitat. And next slide. To help mitigate for the time that the pier had not been installed as required by the commission in violation of the permit, the marina, among other things, restored intertidal habitat at the site to improve the fishery as well as the biological productivity of the area more generally. This photo shows the new intertidal mudflat area, that's the flattish vegetated area, that the marina constructed by excavating fill that was previously in this location and planting the site to enlarge the intertidal area that can function as a nursery for young fish and a catalyst for expanding the area's fish population. And next slide. Now we've reached the end of the presentation and also the end of the day for our beachgoer. They are looking for affordable overnight accommodation, which is critical for visitors, but they are priced out of most options. To increase the stock of affordable accommodation, the Commission consistently requires provision for affordable lodging when reviewing hotel projects. The Commission did so when it approved the demolition of 2 lower-cost hotels in Santa Monica, shown here, which it authorized contingent upon the applicant building a moderately priced hotel at the site. Next slide. Instead of doing so, the applicant constructed this. The Shore Hotel, a boutique luxury hotel with roommates to match, sometimes well exceeding $800 per night. Enforcement staff addressed this violation by reaching an agreement with the applicant in the form of a consent order to pay a $15 million penalty, which has been paid and earmarked for funding affordable accommodation at a nearby state park. Next slide, please. In addition, the order required the respondent to work with the permit staff to obtain Coastal Act authorization for the hotel. This permit required payment of an additional $2.5 million mitigation fee for affordable accommodation, construction of an on-site affordable micro hotel, which is also on the agenda later in this meeting, and to make rooms available in the hotel at an affordable rate. And a note to the public, those room rates can be found by looking for Coastal Escape rates on the hotel website. Next slide. In summary, Section 3821 has enabled staff to resolve more access cases and resolve them more quickly, and thus to realize the vision of the enforcement unit, that is open and available beaches and coastal parks, beach parking and access ways, and the coast without barriers to access. And that was just a quick sampling of the access cases we worked on in Southern California. We're happy to answer any questions you might have.